A live look for you at the U.S. Supreme Court in Washington. We know that justices have just heard oral arguments in a legal challenge that could have a major impact on the upcoming presidential election. Like we say, this could determine, perhaps, if Donald Trump can run for political office. Trump and his lawyers are challenging a December ruling from Colorado's Supreme Court. It said the former president should not appear on the state's 2024 Republican ballot. Similar challenges are pending in other states. CBC's Richard Madden joins us now from outside the courthouse. Richard, tell us what you are gleaning from your vantage point there.
Yeah, demonstrators and supporters, but mostly people who aren't supportive of the former president have really gathered here on the steps of the Capitol. And with these crowds, about 100 people, there's a heavy police presence as well. In fact, this morning, there was a lineup of people wanting to get inside the Supreme Court to hear the 9 justices listen to these arguments from Trump's lawyers and the challengers who brought this case all the way to the high court. And so far, after about 90 minutes of oral arguments, the top justices sounded a bit skeptical of the challenge to not put the former president on the ballot. Of course, this is what kicked off this whole process. The Colorado State Supreme Court ruled that the former president should be removed from the ballot, and they cited this obscure clause under the 14th Amendment. I'm going to read it to you, which says, "No person who engaged in insurrection or rebellion against the Constitution can hold any state or federal office." And the challengers cited Trump's role leading up to those deadly attacks at the Capitol on January 6th. But as I said earlier, some of these judges appeared skeptical of that argument. One judge saying, why should one state dictate who should be voted for to be the president of the United States? Now, here on the ground, we were chatting with both supporters and detractors of the former president. Here's their views as this first historic day of opening oral arguments took place.
I think this is a monumental decision, but I also think it's a very simple decision. You know, this man, Donald Trump, took an oath to the Constitution, to uphold the Constitution. He violated that oath, and I think he should be disqualified. So I think I'm just here to encourage the justices to do their job. It's a very simple case.
Presumed innocence is our God-given right, and without a trial and actually finding him guilty, and based on the evidence that I've seen and what I saw on January 6th here in D.C., he's not guilty of that, and I feel it's a political stunt to silence half of the country.
Now, the Supreme Court is hearing this case. It's the first time the High Court has had to really take a look and determine if that obscure clause in the Constitution would disqualify the former president from being on the ballot. And I should note that the 14th Amendment was really created during the Civil War era as a way to stop Confederate sympathizers from running for office. Now, Trump's lawyers have said that, look, under that clause, the word president isn't mentioned. So they say that this doesn't apply to Donald Trump. But Colorado Secretary of State says, no. The law is clear. Listen to her.
States can rightfully disqualify oath-breaking insurrectionists like Donald Trump, and that is perfectly within the confines of the Constitution and federalism.
Now, former President Trump is not here at the Supreme Court. We're expected to hear his response at Mar-a-Lago at some point in the next hour or so. Now, as for when we can expect a ruling from the Supreme Court, typically the High Court doesn't put timelines on its decision, but legal experts are saying because we are in the midst of the 2024 election, it'll happen sooner rather than later.
Richard, this is the last stop for this legal challenge, and it could set a precedent in U.S. politics. So walk us through the scenarios here. What happens if Trump loses, and what happens if he wins?
Yeah. I mean, that's the ultimate question. The Supreme Court will determine for once and for all if the former president violated this 14th Amendment. So if Trump loses, it basically goes back to the states to make that decision. Each individual state can determine if Trump stays on the ballot or if they have the power to remove him. If he wins, it's basically status quo. The Supreme Court would rule that the former president did not violate the 14th Amendment, so Trump's name stands on the ballot, full stop. ultimately the Supreme Court is really casting a shadow on this consequential election in November. This is a scenario they'd much rather avoid. We have not seen the Supreme Court weigh into an election since 2000. You'll recall Bush v. Gore. So this is a very consequential decision when what the Supreme Court is listening to, and really what it does determine, what its ruling, whenever it happens, will have a profound impact in November.
Okay, Richard, thank you for this. Richard Madden for us outside the U.S. Supreme Court. We are going to stay on this story. I now want to bring in former U.S. federal prosecutor Jessica Roth. She's a law professor at the Cardozo School of Law and is co-director of the Jacob Burns Center for Ethics in the Practice of Law. So, Professor Roth, thank you for joining us. We do appreciate your time today.
It's my pleasure.
I want to start with something that we heard before we heard from the former president there, from my colleague Richard Madden, and he was discussing how one of the justices, Justice Elena Kagan, asked whether or not a single state, of course in this case Colorado, should be able to decide who should be on the ballot in a national election. What do you make of that? What do you make of that question?
Well, that was one of many questions that we heard from the justices that were really, I think, conveying a concern that they shared about what happens if they affirm the Colorado Supreme Court decision disqualifying Trump from the ballot. What does that mean for the rest of the states? And what would that mean in future cases when one state was essentially the first to make a determination about whether a candidate was qualified under Section 3 of the 14th Amendment? Would that decision of a single state bind other states under what we call the doctrine of claim preclusion? Would that potentially mean that even if it didn't bind other states directly, that the fact that the president was off the ballot or a candidate was off the ballot in one state might mean that that individual would lose the national election because they would not have the electors from that state that had knocked him off the ballot? What would happen if other states came to differing conclusions about whether the person was qualified and the U.S. Supreme Court wound up with multiple records to review on appeal with these different determinations and different factual records informed by different, perhaps, rules of procedure and evidence about whether the person had engaged in insurrection, for example? The court just seemed very troubled by all of those possibilities for sort of chaos and disorder and essentially sort of a lack of consistency across the country in the administration of federal elections, particularly the most important election of the President of the United States.
Okay, so this is sort of about giving an answer, I guess, if you will, about how this should all proceed then. Talk to us, of course, about the timing of this, that November, the presidential election is coming up later this year in November. How does the timing of all of this impact the fact that we are now seeing politics and the law collide? What could be the consequences, perhaps, of that?
Well, for now, the former president is on the ballot in Colorado because that state court stayed its decision pending resolution by the U.S. Supreme Court. And so as we move forward also into the other Republican primaries across the country, the former president will remain on the ballot. And so if this case is decided as it appeared today, the court was inclined to rule, which would be in Trump's favor. Then the former president would stay on the ballot across the country, and we could be at the point where he would be the likely Republican nominee. If he wins the general election in November, then depending on how the court's decision comes down, there could be a movement by some who continue to oppose his presidency to seek a determination in the United States Congress that he did engage in insurrection and did violate Section 3 of the 14th Amendment, and therefore he should not be the president of the United States. That was something that was explored at the argument today, and actually something that the former president's lawyers even discussed as perhaps the right remedy if there are enough people who think, including in their members, the representatives in Congress, that he engaged in insurrection. So that would be total chaos and result in political upheaval. More likely, however, the U.S. Congress would not even entertain such a discussion, and he would be, if elected, seated as the president of the United States, notwithstanding the evidence that's alleged also in a criminal case of him having fomented the riot on January 6th and engaged in efforts to overturn the election.
Okay, for today we have to leave it there, Jessica, but I know we will have you back. So much to be watching for in the weeks and months ahead. But for now, thank you. Jessica Roth is a former U.S. federal prosecutor and professor of law at Cardozo School of Law. We reached her there in New York.